So it's the last presentation of the day, and with this I will also say goodbye. So thank you very much for all coming and being here and being part of the event. Our final presentation is by James Parker, should I say Dr. James Parker, right? Who is a lecturer at the Melbourne Law School. And he runs a research center there called Law, Sound and International. His forthcoming book is Acoustic Jurisprudence, Listening to the Trial of Simon Bikindi. And James is also a music critic and radio broadcaster, which might explain his kind of interest is crossing the lines between sort of sound and law, like many of us are doing today. So I leave James with his extensive experience of the trial of Simon Bikindi. So thank you very much. And
yeah, maybe slightly higher. Can we have the slide? And also volume. Have we got audio on the presentation? Right, there we go. So, first of all, thank you to Lawrence for inviting me. Also, thank you very much to Jort and Gabriëlle. It's a real privilege to be here. I'd never heard of an interdisciplinary program like this. We certainly don't have them in law. So I'm really grateful. I just wanted to begin by saying a few words about myself and my work, just by way of context. So I'm a lecturer at Melbourne Law School. I teach legal theory and ethics. And my research is really about law's various different relations with sound. And I tend to think of these relations in two different ways. So I'm just going to quickly outline them. On the one hand, I'm really interested in what I call law's sonic imagination, by which I just mean how legal institutions seem to think about or conceive sound for the purposes of legislation or copyright law or adjudication, how courts attempt to regulate sound and how they think about sound when they're doing so. On the other hand, I'm really interested in what I call the judicial soundscape, by which I'm primarily just referring to the courtroom. So how do courtrooms work as acoustic architectural spaces? In what ways are courtrooms governed acoustically? How's that changing? And what's going on technologically, architecturally, and at the level of what Bourdieu would call habitus? Who speaks in court, when, why, in what ways, and what are the consequences of how all of this is managed and arranged in various different ways. So in law, this is quite a weird thing to be doing. Lawyers tend to be technicists, they're all into rules and things, and there's been a sort of a move in the last 30 years after the sort of linguistic turn across the disciplines towards paying more attention to law's relations with language, increasingly with image too, and for me at least, now sound as well. But it's telling in a way that it took an artist and a curator to invite me to come and speak somewhere, because nobody inside law faculty seems to be interested in this kind of stuff. So I really appreciate that. So I've published a few bits and pieces about what I'm going to present today, so if I don't make any sense, please feel free to look them up. I also have this book coming out later, probably next year now, called Acoustic Jurisprudence, Listening to the Trial of Simon Bikindi, and it's some of that material that I'm going to talk about now. Hopefully briefly. I see some of you are snoozing, so I'll try and keep your attention. The presentation is going to have three parts. First of all, I'm going to talk a little bit about Bikindi and some of the circumstances around his trial. Then I'm going to talk a bit about his songs, what the tribunal said about those songs, their role in the genocide, and what it sort of did with them in relation to particularly the music, voice, lyric relations. And then finally, I'm going to talk about the trial itself and how Bikindi's songs featured at trial. And in particular, I'm going to consider this one really interesting moment, I think anyway, where at the end of the trial, Bikindi, totally a cappella, totally unaccompanied, actually sang his final statement to the court. I'm just interested in what on earth was going on there. So, between September 2006 and December 2008, Simon Bikindi stood trial at the International Criminal Tribunal for Rwanda. The details of the case were extremely complex, so I'm not going to bore you with them. But the essence was really very simple. Basically, in the early 1990s, Bikindi was one of Rwanda's most well-known musicians and popular figures. He was really a genuine celebrity there. Probably the most talented artist of his generation, according to one commentator, Rwanda's Michael Jackson. And by the end of 1994, his songs had literally soundtracked a genocide. Recordings of the songs were sold and distributed on audio cassette. They featured extensively on the radio, where they were often accompanied by very inflammatory and heavily racialized commentary by radio announcers. And Bikindi himself performed many, many times at various rallies across the country. Here's some images of that. They're from a dodgy old VHS, so not the best quality. Most shockingly of all, though, were reports that Bikindi's songs had actually been sung by the perpetrators of the genocide as they hacked or beat to death hundreds of Tutsis with government-issued machetes and homemade nail-studded clubs. That quote's from the New York Times, but it was reiterated by a witness who testified at the trial. They said, members of the population knew his songs by heart, and when they perpetrated those crimes, they would sing those songs. They would say that they were furious and that they wanted to avenge the deaths of their relatives. And here's an example of one of these songs that was being sung literally. It's important to bear this in mind, I think, so that we don't over-aestheticize this. Being sung literally as people were being hacked to death. So this is why Bikindi was indicted by the tribunal. That voice, those rhythms, these sounds. The ICTR was established, this is the tribunal, the ICTR was established by the UN immediately after the genocide in 1994, and it was meant to prosecute only those the most responsible for the genocide. It mostly went after politicians, leaders, military leaders, journalists, and priests. But one singer, this guy Bikindi. So there's a very strong claim being made by the tribunal, I think, here about the importance of music, the importance of singers, and their potential in relation to violent acts, as well as, you know, all of these great romantic cliches about music being, you know, enriching for the soul and nourishing just necessarily. In his opening statement to the court, the chief prosecutor of the ICTR put it like this. Said, the accused Bikindi had a talent in art and music, a talent which should normally be directed to enriching the cultural heritage of any community, directed at strengthening its social cohesion and solidarity. But Bikindi chose a different objective for his acknowledged talent. He consciously and deliberately made his artistic works the vehicle for inciting other Rwandans who respected his talent to indulge in the atrocities of 1994. A little bit later on, Bikindi's music infected people's minds with ethnic hatred and persecution and served to mobilize the youth to join the Interahamwe militia. Now, there's really a lot going on in just those two paragraphs, I think. I'm not going to dwell on that now. For now, the really important point is that because of his songs, Bikindi was understood by the tribunal to be one of the most responsible for the deaths of about 800,000 Rwandans. So here's a singer being accused by a UN body, which is to say nominally on behalf of us in this room, of inciting genocide with his songs. He was indicted in July 2001. An arrest warrant was issued by a judge at the tribunal. Within days, he was arrested, not actually very far away from where we are now, in a center for asylum seekers in Leiderdorp. Probably got that pronunciation horribly wrong. He'd fled Rwanda through Uganda to Holland after the genocide. He briefly battled extradition, but failed and was taken to a jail in Tanzania where he awaited trial. It took 5 years for the trial to come to a head. Officially began in 2006 and lasted 60 days in total, comprising hundreds of hours of witness testimony, oral argument, and these were spread over a period of two years. So finally, in 2008, we finally get a judgment, which incidentally had to be read out viva voce, and that's interesting too, I think. I've written about that as well. What does the court decide? Well, it says that there were 6 charges against Bikindi in total. Again, I'm going to spare you the details, but they say that he's innocent of 5 of those charges and guilty of one count of direct and public incitement to genocide, and they sentence him to 15 years in prison. Crucially, though, it's not actually his songs in the end that he gets done for. Bikindi, the court said, he'd used a public address system to state that the majority population, the Hutu, should rise up to exterminate the minority, the Tutsi. Bikindi used the same system to ask if people had been killing Tutsis, who he referred to as snakes. So this was the speech that he got done for. 15 years in prison followed on from this speech act on the side of the road one day in 1994. As for the songs, the court said the speech had incited genocide, but the songs, they had just encouraged hatred. Okay? So the songs had been used by presenters on the various different radio stations in Rwanda to incite genocidal killings. But that wasn't Bikindi's intention. It was only found that he had intended to encourage ethnic hatred. So he was guilty of incitement in relation to his speech, but not his songs. The songs are bad, but they weren't genocidal, the court said. So that's the Bikindi case, very, very briefly. I just want to tell you a little bit through the court's reasoning process in getting to that decision now. The judgment itself is very long. It's 125 pages. Law is very slow. And in the book, I run quite a long argument about what's going on here. And what was going on here, very, very briefly, was that when the court thought about Bikindi's songs, it really didn't care very much about their sound. And so that's the argument that I'm going to sort of track through now. Only 3 songs were explicitly at issue in the Bikindi case. These are the songs that the prosecution decided were the most inflammatory of his various different recordings, that did the most damage and were the most responsible for bringing about the genocide. And they devoted, in the judgment, about 20 pages to the so-called meaning and interpretation of these songs. They read as follows. By the way, the subheading here is already revealing, I think. So the chamber notes that several witnesses highlighted the background music of the songs. For example, the accompanying sitar, the mixed Rwandan Congolese rhythm, and the accompanying traditional dance. Many witnesses spoke positively of his music, describing it as captivating, catchy, having good rhythm and melody, and making listeners want to dance. While the chamber doesn't doubt Bikindi is a talented and popular musician, the chamber's less interested in the score than the lyrics of his compositions. While the defense argued that the principal purpose of a song is usually entertainment based on melody and rhythm and need not even have a message, the chamber finds that, if anything, emphasizing the popularity of the songs may have had the effect of assisting the prosecution's case regarding their impact. So what's going on here? Well, I think clearly, the chamber begins by separating Bikindi's songs out into 2 parts. And this distinction it sustains for the rest of the judgment. So on the one hand, we have the lyrics, which are foregrounded and primary in the analysis. And then we have the music, which is backgrounded and secondary. Music here is an accompaniment, essentially. It might be captivating, it might be catchy, rhythmic, melodic, and eminently danceable. But insofar as it is, we understand in this part of the judgment that these factors don't contribute to the song's meaning or signification. Music affects a song's popularity, but it doesn't affect its all-important meaning and interpretation. As far as that's concerned, it's just not relevant. So the chamber professes to be more interested in the lyrics of his compositions, as if the act of interpretation simply involves stating a preference between those two aspects and then just moving on. From a musicological perspective, the obvious problem, I think, with this argument, although it's not always so obvious when I talk to lawyers, is that this foreground-background distinction on which this the whole judgment rests is just a fallacy. What the chamber fails to realize, what the court fails to realize in this analysis, is that the issue when you're thinking about lyrics isn't words, obviously, but words that are performed, that are vocalized, that are acoustic, that are sonorous. Simon Frith, in a really great essay on the voice-lyric relation, in relation to popular songs, says, lyrics are a form of rhetoric or oratory. We have to treat them in terms of the persuasive relationship they set up between singer and listener. And from this perspective, you might say that a song doesn't exist to convey the meaning of the words exist to convey the meaning of the song as a whole. And the court's failure to, even for a moment, consider that Bikindi's music might bear some sort of relationship to the song's meaning and interpretation, rather than simply just maximize their entertainment value or their popularity, I think that's a real problem. We have to understand it as really a failure by the court to understand how songs work, what they do, and how they mean. But it's an interesting failure because it was deeply institutional. So the court didn't just pluck this approach to Bikindi's songs out of nowhere. It never quite made its approach explicit, but this same approach was operative all the way throughout the trial. It was a really kind of an institutional approach to Bikindi's songs. So loads of the witnesses loads of witnesses were called upon during the course of the trial to testify about Bikindi's songs. But it was really 3 expert witnesses that did most of the work and that the court relied upon most in its judgment. But it wasn't simply a matter of one institution, the court, reaching out to these experts, in the academy in order to sort of bring in knowledge from the outside in some sort of pure sense. The production of expertise was really carefully managed and coordinated by the tribunal in at least 2 senses. So first, the kinds of experts it sought out, just to begin with, and second of all, the limited capacity in which those expert witnesses were called. So all 3 experts who were called at the trial were linguists. In other words, from the kinds of experts that were selected, we can already infer a lot about what the tribunal regarded as important in relation to Bikindi's songs, foreshadowing precisely the kind of logic that you find in the judgment a couple of years later, where the meaning and interpretation of Bikindi's songs is concerned, sound or music just doesn't register as relevant data at the level of the selection of experts. No one put this actually more succinctly than one of the experts themselves in the expert report he tendered on behalf of the defense. It seems that this kind of exclusion of music and of sound was actually a condition of his employment by the tribunal. So it's in French. Selon le contrat, le travail ne doit pas s'entendre sur les questions de musicologie. So according to the contract, the work shouldn't extend to questions of musicology, pardon my terrible pronunciation, but rather to the text of the so-called political songs, which should be analyzed relative to the historical, socio-political, national, and international context in which they're created. In other words, the analysis that he's contracted to offer actively prescribes the musical qualities of these songs at the level of the contract. They're contracted out of the conversation. Why would the tribunal approach Bikindi's songs this way? Well, that's a complicated question, but one is kind of obvious, and that's just the law that the tribunal had to work with. So in its discussion of the relevant international law relating to freedom of expression, the Chamber explains that the international definitions of expression and speech are broad enough to include artistic expressions such as songs. Expression has been defined as the freedom to impart information and ideas, either orally, in writing or in print, in the form of art or through any other media of his choice, and express and disseminate his opinions. On this basis, the court says it was happy to consider, sorry, I'm missing a quotation here, the words accompanying a score of music, as comparable from a legal perspective to the words used in speech, and therefore both limited and protected by international criminal law in the same way. So lyrics in songs are like words in speech. And the focus is on the lyric and the focus is on the words, right? So this authority doesn't really speak about music per se, but its mediology, I think, comes through very clearly. Expression for the purposes of international law, and here are the various different right documents that are being invoked here, is about information, opinions, ideas, and messages. In other words, it's about content. As far as form is concerned, the relevant statutes and treaties are basically ambivalent. Any medium will do. A song is as good as a speech, is as good as a newspaper article. Why is that a problem? I think it's a problem for two reasons. First, because by reducing expression to the register of content, this approach effectively renders the affective qualities of music non-justiciable. They're just not relevant. We're only interested in content, not meaning, rather than what a song does. Which is to say, it puts out of reach, juridically, precisely the dimension of a song that matters most, actually, to most people as listeners. And the second reason it's problematic is because it's very easy to move from this mediological ambivalence to the mistaken idea, and I think it is a mistaken idea, that form, that is sound or music, is irrelevant to the project of interpretation. So here's counsel for the prosecution at one point during the trial. The fact that it's a song is not the point. They were openly talking about killing the Tutsi, and when I say openly talking about it, they sang about it too. And it's simply a matter of communicating that direction, whether it is a song or a speech or a written pamphlet. Music on this account is just an empty vessel, right? It's a delivery system, a way of getting an idea from point A to point B. And in practice, the result of framing music as simply a means of communication is to make it irrelevant to the task of hermeneutics. Once it's been rendered as just a method for delivering linguistic content, the tribunal is freed up to get on with the proper legal work of verbal analysis. In other words, by making music, the acoustic dimensions of Bikindi's songs irrelevant to the task of interpretation, I would argue that the tribunal failed even on its own terms. It simply didn't have an adequate account of the meaning and interpretation of Bikindi's songs. And given that the theme today is voice, I just want to be a little bit more explicit about that theme and before we move on to the final part of the presentation. In its description of the background music, that we had up on the slides a few minutes ago, the Chamber refers to a few things: the accompanying sitar, the melody, and the rhythm of the songs, which it says makes listeners want to dance. And Bikindi's voice just doesn't get mentioned at all. And this is significant, I think, because the voice is the kind of axis where lyric and song come together. Right? It's precisely in the voice that we move between word and song. So this distinction, it's at the level of the voice that the form, this distinction between form and content, medium, message, idea, expression, which is so central to the tribunal's account at the level of legal doctrine, most obviously breaks down. So it's the musical voice, I'd want to say, that renders this foreground-background distinction, lyric in the foreground, music in the background, that's insisted on by the Chamber at its least tenable. And this is a real problem, I think. If a UN body, like the ICTR, is going to attempt to hold people like Bikindi responsible in law for their songs on behalf of you and me, surely it has a responsibility to take sound voice music the particular ways in which they complicate or exceed the registers of language and meaning and intention a lot more seriously, basically. They're not incidental, they're not marginal, they're not background, they're central to what songs are, how they work, and how they make themselves meaningful. So, part 3, and we're moving on now from how the tribunal thought about Bikindi's songs, so its sonic imagination, to how those songs featured at trial. And as a result, we're also moving away from primarily textual sources to the audio-visual recordings of the trial itself, which I had access to when I spent a month or so at the tribunal back in 2011. So Bikindi was sentenced to 15 years of imprisonment on the basis of the judgment we've just looked at. He got credit for the 7 years he'd already served since his extradition from Holland back in 2001, and he appealed. And at about 3:45, to be precise, on the afternoon of 30th of September 2009, after 6 hours of oral submissions, his appeals hearing is just on the verge of drawing to an end. No incidents really, not very interesting. Counsel for Bikindi is just finishing summarizing his closing argument. There's an exchange of a few sort of amiable formalities, and it looks like
both
this.
My analysis of the Rwandan law and the national provisions are, in my submission, of a persuasive nature.
Thank you, Counsel.
Thank you.
Mr. Chair, have you concluded?
Oh yes, Mr. President, I was waiting any other questions.
No more questions.
Thank you.
Thank you very much.
And then finally, at 4 o'clock, exactly according to the minutes of the case, the presiding judge offers the floor to Bikindi himself for one last time before the hearing comes to an end and it's all over. And let me just preface this next clip by saying that nobody present, apart from Bikindi, his defense team, and a couple of the interpreters present, had any idea what was going to happen next.
Well, in that case, I have to inform Mr. Bikindi. Mr. Bikindi, that you have an opportunity now to make a statement. If you wish to, you may make a statement.
Merci, Monsieur le Président. Merci, honorable juge. Ma déclaration est simple. Ibibi byabaye mu Rwanda n'amahana atagira les événements n'amarorerwa atagira uko avugwa bagenzi n'agahomamunwa iyemwe ntibikongere rwose ntibikongere bibaho rubanda ntibikongere kuba mu Rwanda.
The performance goes for about 6 or 7 minutes, so I'm just going to jump to the last minute or so of that now.
Ibibi byabaye mu Rwanda n'amahana atagira izina n'amarorerwa atagira uko avugwa iyemwe n'agahomamunwa bagenzi ntibikongere rwose ntibikongere bibaho rubanda ntibikongere kuba narindi. Merci beaucoup, Monsieur le Président. Merci beaucoup, honorable juge, de m'avoir accordé cette parole.
Thank you, Mr. Bikindi. That ends the hearing. We are adjourned.
So there's a complete failure to engage here, right? Order gets restored to the court by means of this formulaic speech act, we are adjourned, which is palpably, even comfortingly, I think, legal in terms of its sound, its content, and what John Austin would call its illocutionary force. That ends the hearing. We are adjourned. and the performance isn't mentioned at all in the appeals judgment. So what should we make of this, this episode, which is kind of remarkable, I think? Well, let's begin with the obvious. If this is worthy of comment, I think it's probably because we don't expect Bikindi to sing, right? We expect him to speak. And more to the point, because to sing in this context in a trial feels transgressive somehow. It feels daring or political or actually funny. Everyone always laughs when they see that last bit of the clip. Why? Because we're in a courtroom and we're not in a concert hall, right? Before we consider Bikindi's performance itself, we need to say something about the setting. And it's the setting that I call in my work the judicial soundscape. And this is always true, right? And I realize I'm preaching to the choir to some extent here, but nevertheless, the meaning and the power of a song are never simply in the song, in the lyrics, in the notes, in the rhythms, in the timbres of the voice and the harmonies, etc. Musical meaning is always a function of context to some extent, which is to say the way in which that listening experience is framed. So when it's piped through, the tinny, treble-rich speakers in a shopping center, the same piece of Mozart, for example, which in concert is, sublime, becomes, just another bit of marketing, right? And a highly effective one at that, a form of what Jonathan Stern calls sonic architecture. Whereas in a train station, that same piece of music would become what an example of what Steve Goodman calls sonic warfare, literally a weapon for, warding off antisocial yobs, as this article puts it. And then, in the car, by contrast, it would become something that you use to help you unwind at the end of the day. So no listening situation is neutral, is the point. Every soundscape has its norms, conventions, rules, politics, and clearly the fact that Bikindi was singing in a courtroom rather than a concert hall or a shopping center or in your car was significant. And it's significant because the trial is just not a context in which we expect to hear music very often. Fundamentally, the judicial soundscape is oral and it's discursive. We expect to hear voices and voices in conversation with each other, and we expect them to speak and not sing. The singing voice, though, isn't just unfamiliar. It's not just a matter of we don't get it very often in court. I think it actually feels out of place. One witness, when they were invited to sing a portion of Bikindi's song at trial, one of his songs, put it like this. They said, of course there are songs of Bikindi that I know, but I would not dare burst into song. Now this word burst, I think, is telling. It reveals something important that the witnesses intuited about the setting, which is to say that in the judicial context, song is both inappropriate and excessive. It's an overflowing, an eruption, a bursting forth, right, of emotion, affect, beauty, potentially, but either way, otherness. Legal theorist, critical legal theorist Peter Goodrich writes that the law, both as an institution and as a profession, represents itself as an arcane and elite pursuit. Its image of a language is that of a peculiarly legal reason, that of the logic of rules. And this maps onto acoustics, I think. So in acoustic terms, this self-representation, this familiar myth of legal rationality, makes itself felt at trial in the difference between speech on the one hand and song on the other. So speech seems to stand acoustically for sober reason and rules, and helps phenomenologically to produce this aura of rationality and of specialism that you get at legal hearings. Whereas song becomes a sign of passion, illogic, and the ineffable, the law of the heart, you might say, rather than the law of the mind. In the Western courtroom, in other words, and despite its location in Tanzania, this courtroom at the ICTR, I'd suggest, is very much a product of the West. In the Western courtroom, speech actually sounds legal, whereas song doesn't. Song isn't just unusual in the juridical context, it's everything, actually, that legal expression in the West is not supposed to be. One just final point before moving on to the performance itself very quickly. Obviously, not all performances in a legal context are equally, musical performances in a legal context are equally transgressive or political. And so the trial, I think we should think of the trial as comprising not just one listening situation, but many. And we see this very clearly in the Bikindi case. So the final statement that we've just heard, it wasn't the final statement, the final song that we just heard, wasn't the first occasion that Bikindi's music got played at trial. One of the judges referred to it as a musical trial. Because recordings of his song got played throughout on CD, DVD, and tape. Witnesses regularly sang, they hummed, they were called upon to do so by the tribunal. But what you see when you look at the transcripts and you look at the audio and audiovisual archive is that these performances are always very carefully stage managed. I'm not going to go into this in detail now, I do in the book, but I just wanted to point out that when music is called upon in the trial, it's always for very particular reasons, and you're being asked always to listen in very particular ways. So it's a kind of domestication, I think, of some of the transgressive qualities of music as it's brought into the trial. What makes Bikindi's final statement, though, different to these other examples is his ability to sort of take ownership in a certain kind of way of the listening situation. He's sort of wresting it away from the tribunal. And when he does that, I think he has multiple audiences in mind. And that's one of the reasons that it's so interesting, I think, because this final statement is so sort of multivalent and ambiguous and conflicted even, maybe. It doesn't submit itself to the ordinary rigors that the court would want to demand of music in the courtroom. And I think that's where it gets some of its transgressive flavor from. So one of the audiences being addressed here is clearly the tribunal. So we can think of Bikindi's decision to sing at this crucial moment right at the end of his trial, I think as an appeal to conscience on one level, an attempt literally to move the court, to insist on his status as an artist, and to play on this link we sometimes make between artistry and the ethical. Maybe. But if so, Bikindi surely knew that he ran a risk of being misconstrued here, right? Because this was a tribunal that he's singing to, maybe attempting to appeal to their conscience, that has declared his songs to have encouraged ethnic hatred. Maybe not genocide, but ethnic hatred, right? And the court knows that these were sung deliberately and by a large number of people, actually as they were committing acts of genocide. So Bikindi must surely have known, I think, that when he sings at this last moment, that maybe he's going to be understood as doing it in bad taste, right? So it's hard not to read this as also an act of defiance or dissent on some level, a refusal to submit to the authority of the tribunal, which has already imprisoned him for 8 years and is probably going to lock him up for 15 years, for at least 7 years more. So it's an appeal to conscience on one level, it's defiant, but I think it's also an incredibly personal gesture on the other hand as well. So song is Bikindi's profession. It's literally his favored means of expression. And not just that, song, I think, is incredibly personal as a means of communication per se. So here's Italo Calvino in an amazing short story, which you should all read, called A King Listens. Above all, he says, a voice means this. There is a living person, chest feelings, who sends into the air this voice different from all other voices. Adriana Cavarero, an Italian philosopher, talks about a vocal ontology of uniqueness, whereby before it conveys any content, the human voice always communicates first and foremost itself, its uniqueness, the singularity of the person, this person, and no other person. So both at the professional level, as Bikindi is a singer, and also at a metaphysical level in a way, there's clearly an extent to which this decision to sing can be understood as an expression of selfhood, just sort of bare selfhood, a refusal to be reduced to law's categories, genocidaire, or even artist or Rwandan for that matter. On the other hand, I don't think we can read this final moment as just an expression of selfhood. It's clearly engaging a tradition. And it's within a genre as well. No music, in fact, can ever be absent a lineage or a relationship to lineage or a relationship to genre. Genre is a key part, even when the genre is being transgressed, of what gives a piece of music its meaning, what makes it comprehensible to us, and prevents it from being just, noise. So I don't think we can understand this performance as an expression just of selfhood. When Bikindi sings this final statement, I think we have to understand him as singing to Rwandan audience who are capable of understanding what's going on at the level of genre here as well. His audience here on one level is explicitly the Rwandan people. And he's well aware of this. He's well aware of the mediascape in which he's operating. He knows that there are Rwandan journalists there, Rwandan members of the public, that are actually present in the public viewing gallery and listening gallery, and that his performance is being recorded by the tribunal for posterity. The cameras and microphones are very, very present, and that these might one day be distributed. And in fact, we can see this at the level of his lyrics. Were I again to have the opportunity to sing, he's singing this, right? This is the lyrics of this song, to sing for Rwandans. I would go to the country of 1,000 hills so that all Rwandans can hear me. I would climb right up to the highest peak, and once at the pinnacle, I would lodge my appeal. Right, well, he's doing it. The courtroom here is being reframed by him as a kind of a media device. It becomes his highest peak, right? It's a tool for addressing the Rwandan people, and for addressing them, moreover, in a way that, in a certain kind of way, only they can understand. Only those who are familiar with the genres of Rwandan song can understand. And so if some of the meaning of this song, I think, is lost on us, non-Rwandans, and on the court, I think, that shouldn't be particularly surprising to us. It's not just that we don't understand the words he's singing. In fact, when we focus primarily on the lyrics, which is what the judges seem to have done, they were wearing headphones so they could hear the interpretation of the song. We're simply missing the point to some extent. It's the music here that matters. And as outsiders to a Rwandan musical tradition, there's just a lot about this performance that we can't help but miss, inevitably. Part of the meaning of this final address, then, I think, comes precisely in this refusal to speak, right? To employ a language, which is, say, the language of music, to precisely exclude, in a certain kind of a way, some of the listeners present and in this room right now. So song becomes a kind of a reminder of the post-colonial context in which we're working in, and an exemplification of some of the difficulties which that context elicits. I'm aware that I haven't got very long left, so just a couple of final points. It's really important when we think about this final song, I think, to understand that historically in the region, the Great Lakes region that Rwanda is now in, or the state that we now call Rwanda is in, the musician and the singer are much more important figures than they are in, for example, the Netherlands today. Authority is symbolized and passed on between regimes, governing regimes in that area, literally by passing on a drum called kalinga. The dynastic drum is called. So, and traditionally, the singer, as a figure, was a member of the royal court. They were a poet, historian, and part of their job is literally the perpetuation, communication, continuation of local traditions, laws, customs, norms. And as a result, their voice traditionally commands a certain kind of authority. Now, it's true that Rwanda's political and legal structures have massively changed by the time of the genocide in 1994. But nevertheless, this tradition is not ancient history by the time of Bikindi. Bikindi is not a member of any royal court, but the fact that throughout the region's history, music is intimately bound up with its structures of authority, I think should help to color in a certain kind of a way this performance. So we can understand Bikindi's decision to sing as an affirmation at the level of form, at least as much as content, of a certain kind of, a certain brand almost of traditional Rwandan values, and an assertion of both political and juridical sovereignty in the face of an institution that hasn't always been free of charges of imperialism. So it's transgressive, and it's an assertion of sovereignty in a certain kind of way. But I don't want to exaggerate the importance of this final moment, on the other hand, because although it's transgressive, although it's really interesting and complex, actually in the end it's no great challenge to the tribunal's authority. Critical legal theorist Cornelia Wissmann argues that the final statement exists totally outside of the normal rules of procedure. How a defendant fills up the discursive frame allotted to him is his decision alone. Above all, he's allowed to pull out all the stops in an effort to make the judge more favorably disposed towards him. Heartrending tales of woe, irrelevancies, untruths, they're all permitted. There is not even there is not even a limit specified for the amount of time the last word may take up. Here, everything must be allowed to be said. Or, for that matter, sung. So, the final statement is the one moment at the trial when the ordinary listening situation is suspended. And it's this fact, I think, that enables Bikindi's transgression on the one hand, but also ensures its containment in a certain kind of a way. So for Wissmann, the final statement isn't just a procedural oddity, because it comes after the hearing of all the evidence, after the trial is effectively over and has no bearing on the facts. There's an extent to which it's simply not part of the trial in a meaningful way at all. And sure enough, it's not even mentioned in the ICTR's rules of procedure and evidence. We can think of it as a kind of a purposeful anomaly inserted into the trial, a luxury of sorts, both for the defendant and for the court itself. So if it seems like a gift to the accused, it's a gift that only an institution in a position of absolute authority could ever give. So yeah, I'm not gonna conclude. I'll just leave that stuff hanging there. Hopefully there's something provocative that resonated with you in some kind of way. Thanks a lot.
Thank you, James.